have a warrant. Step aside.
Show me the warrant.
We don't have to show you.
Yes, you do.
You're interfering with an investigation.
A warrantless search is illegal.
The officers announced they had a warrant to search the property and ordered her to step aside. She requested to see the warrant first. They informed her they didn't have to show her anything and were executing a lawful search. She calmly noted that under the Fourth Amendment, they were required to present the warrant before entry. The lead officer warned her she was interfering with a police investigation, a criminal offense. She countered that conducting a warrantless search constituted a federal civil rights violation, and added that she prosecuted that crime for a living. At exactly 7:15 a.m. on a Saturday morning in Philadelphia, 3 narcotics officers thought they were about to execute a routine drug raid. What they didn't know was that the woman standing in that doorway had sent 14 corrupt cops to federal prison in the past 3 years. They didn't know she understood constitutional law better than their entire department. And they definitely didn't know that this wasn't a mistake, it was revenge. In the next 23 minutes, everything they thought they knew about intimidation was about to collapse. Before we continue, if you believe corrupt officers should face real consequences, hit that subscribe button right now. Drop your country or state in the comments, and let me know, should police who file fake warrants go to prison? Because what happens next proves exactly why your rights matter. This story gets absolutely wild. Tina Hallman was not supposed to be home. At 29, she had already carved out a reputation that made seasoned detectives nervous and defense attorneys recalculate their strategies. As an assistant United States attorney in the Eastern District of Pennsylvania, she prosecuted a specific kind of case, police corruption. Not the minor infractions. Not the gray areas. The deliberate violations. Evidence planting. False testimony. Warrants built on lies. She had spent 3 years methodically dismantling careers, and her conviction rate sat at 87%. But on this particular Saturday morning in Philadelphia's Fishtown neighborhood, she was just a woman in sweatpants and a damp t-shirt, still catching her breath from a 5-mile run through streets that smelled like coffee and old brick. Her converted warehouse loft occupied the 3rd floor of a building that had once manufactured textiles and now housed artists, freelancers, and one federal prosecutor who preferred exposed pipes and high ceilings to suburban comfort. The pounding started at 7:15 a.m. Not a knock. A demand. Tina paused halfway through unlacing her running shoes. The sound came from the ground floor entrance, heavy, rhythmic, impatient. She moved to the intercom, pressed the button, and heard a voice that carried the unmistakable edge of authority announcing itself. 3 officers. Tactical vests. A warrant for the premises. She kept the chain on and opened her 3rd floor door just wide enough to look down the stairwell. From 3 floors up, she could see them clearly: Detective Clinton Rabin, 44, broad-shouldered and gray-templed, flanked by 2 younger officers whose name tags read Vance and Pierce. Rabin's hand rested near his belt. His stance suggested this was routine. His expression suggested he expected compliance. Tina kept her voice level and asked to see the warrant. Rabin looked up the stairwell, annoyance flickering across his face. He informed her they were executing a lawful search and that she needed to step aside immediately. She repeated her request, noting calmly that the Fourth Amendment required presentation of the warrant before entry. Not after. Before. The annoyance sharpened into something harder. Rabin's jaw tightened. He took a step forward and informed her that interfering with a police investigation was a criminal offense. He suggested she reconsider her position. Tina did not move. She countered that conducting a warrantless search constituted a federal civil rights violation under 18 U.S.C. Section 242. She suggested he reconsider his. The stairwell went quiet. Rabin stared up at her. Vance and Pierce exchanged glances. For a moment, the only sound was the distant hum of Saturday morning traffic filtering through the building's old windows. Then Tina made her demand explicit. She instructed him to slide the warrant under the door, not her door, but the ground floor entrance. She would read it there. Until then, no one was entering. Rabin hesitated. His hand moved toward the document folded in his vest pocket, then stopped. He seemed to be calculating something: risk, procedure, the likelihood that this woman in sweatpants actually knew what she was talking about. Finally, he pulled out the warrant, crouched down, and slid it under the steel door. Tina descended the stairs slowly, picked up the document, and returned to her apartment. She did not invite them in. She did not offer explanations. She simply closed her door, chain still fastened, and began to read. 2 full minutes passed. In the hallway below, Rabin shifted his weight. Pierce checked her watch. Vance muttered something under his breath about uncooperative civilians. But Tina heard none of it. Her focus had narrowed to the pages in her hands, and what she found there made her pulse quicken, not with fear, but with recognition. The affidavit cited a confidential informant who had allegedly made multiple controlled buys at this location over the past 6 weeks. It described surveillance of heavy foot traffic consistent with narcotics distribution. It listed the building address but failed to specify which unit. The CI's name was redacted, as expected, but the description of the alleged buys was vague to the point of uselessness. No dates. No times. No corroborating surveillance photos. Just broad assertions and a judge's signature at the bottom. Judge Harlan Brooks. She knew Brooks. He was meticulous. He would never have signed this under normal circumstances. She scanned the document again, noting every gap, every missing detail, every tell of a warrant constructed not to find evidence but to justify entry. The narrative described an occupant matching the description of someone involved in street-level distribution. It mentioned a single visitor to the downstairs unit. One visitor. That was the entire basis for claiming this building was a drug hub. Tina stepped back into the hallway, warrant in hand. Her voice remained calm, but the questions came fast and precise. She asked Rabin for the CI's name. He responded that it was confidential. She asked for the dates of the alleged controlled buys. He said they were in the affidavit. She asked why the entire building was listed when the surveillance logs, visible in the attachment, showed only one visitor to the downstairs unit. Rabin's jaw worked. Sweat beaded at his hairline despite the cool morning air. He repeated that everything was in the affidavit, that the warrant was valid, that she was delaying a lawful search. Tina asked why no specific apartment number appeared anywhere in the document. Rabin did not answer immediately. His eyes flicked to Vance, then back to Tina. He opened his mouth, seemed to think better of it, and simply stated again that it was all in the affidavit. Tina let the silence stretch. Then she spoke the words that changed everything. She identified herself as an Assistant United States Attorney with the Public Corruption Unit in the Eastern District of Pennsylvania. She informed Rabin that she prosecuted officers who filed false warrant applications for a living. She had secured 14 convictions in 3 years. She knew every trick, every shortcut, every lie that desperate or lazy cops told magistrates to get signatures. And this warrant, she continued, was a textbook example of fabricated probable cause. She told him she would be filing a formal complaint with the FBI Public Corruption Task Force by Monday morning. If he or his officers crossed her threshold, if they executed this defective warrant, she would personally ensure that federal charges under Section 242 were filed before the week ended. Deprivation of rights under color of law. Civil rights conspiracy. False statements to a judicial officer. She let that sit. Rabin stared at her. His mouth opened slightly, then closed. Behind him, Vance and Pierce had gone completely still, their earlier bravado evaporated. Rabin's hand, which had been resting near his belt, dropped to his side. For 10 long seconds, no one moved. Then Rabin stepped back. He glanced at his officers, some unspoken calculation passing between them, and gestured toward the stairs. The 3 of them retreated down the steps without another word, their boots echoing in the narrow stairwell until the sound faded and the front door clicked shut. Tina stood in her doorway, warrant still in hand, her heart hammering against her ribs in a way that had nothing to do with fear and everything to do with fury held in check. She closed the door. Locked it. Set the warrant on her kitchen counter. Then she pulled out her phone and dialed her supervisor at the U.S. Attorney's office. It was 7:38 a.m. The first investigation would be opened within the hour. The calls began before the coffee finished brewing. Tina's supervisor, First Assistant U.S. Attorney David Keller, answered on the second ring. His tone shifted from weekend casual to prosecutorial focus the moment she described what had happened. He instructed her to photograph the warrant from every angle, preserve any communication attempts from the officers, and stay home until he could arrange for FBI agents to collect the original document as evidence. He would contact the Public Corruption Task Force directly. Internal Affairs at Philadelphia PD would be notified within the hour. By 8:30 a.m., 3 separate investigations had been formally opened. Tina sat at her kitchen counter, the warrant now sealed in a plastic evidence bag that an FBI agent had delivered along with a digital recorder for her statement. She walked through the encounter twice, once for Keller and once for the FBI, her account precise and unemotional. The agent, a woman in her 40s named Teresa Bowen who specialized in civil rights violations, listened without interrupting, taking notes in a small leather notebook that looked like it had survived a decade of investigations. When the formal statement concluded, Bowen asked a question that would prove significant later. She asked if Tina had ever prosecuted anyone connected to the narcotics unit that had come to her door. Tina paused. Then she remembered. 6 months earlier, she had secured a conviction against Officer Randall Torres for evidence planting and civil rights violations. Torres had been assigned to a different precinct, but narcotics divisions talked. Officers knew each other. The connections were informal but real. She mentioned this to Bowen, who made a note and said nothing further. The rest of Saturday unfolded in a strange suspension. Tina reviewed case files, answered follow-up emails, and tried to focus on work that suddenly felt distant. Her mind kept returning to Rabin's face in that final moment before he retreated, the flash of recognition, the recalculation of risk, the defeat. She wondered how many people had opened their doors. How many had stepped aside without reading a single line? How many had trusted the badge and the vest and the authority in the voice, never knowing that the warrant was defective, that the probable cause was invented, that their Fourth Amendment rights were being violated in real time? By Sunday morning, Tina had pulled the warrant out again. She cross-referenced the judge's name with court records, verified the filing timestamp, and noted the pattern she had seen before in other cases. Friday afternoon submission. Last hour before the courthouse closed. A judge presented with a stack of paperwork and limited time to review each one thoroughly. Judge Harlan Brooks was many things: experienced, careful, constitutionally rigorous, but he was also human. And on a Friday at 4:47 p.m., rushing to clear his docket before the weekend, even he could be misled by an affidavit that looked superficially complete. The sloppiness was not an accident. It was a feature. Defective warrants worked because they were designed to survive a glance but not scrutiny. Monday morning arrived cold and clear. Tina drove to the federal courthouse on Market Street, the warrant in her briefcase, her testimony prepared. She briefed Keller in his office, walking him through each defect point by point. He listened with the expression of a man who had seen too many of these cases and knew exactly how they would unfold. By noon, Detective Clinton Rabin had been placed on administrative leave pending the outcome of the investigation. Tina sat in her office that afternoon, reviewing Rabin's personnel file that Internal Affairs had forwarded as part of the joint investigation. 2 prior complaints. Both involving warrant applications that were later questioned. Both resolved internally with additional training and no formal discipline. The pattern was clear. The system had protected him twice before. It would not protect him a third time. At a red light on her drive home, Tina found herself replaying the confrontation. Rabin's face. His hesitation. The moment he realized she was not going to comply. She thought about all the others, the people in neighborhoods where 3 officers in tactical vests were not unusual, where demanding to see a warrant might get you arrested for obstruction, where knowing your constitutional rights was a luxury most could not afford. How many had simply opened the door? Do you think you would have demanded to see the warrant and read it line by line, or would fear have made you open the door? Type, "I would stand my ground," or "I would call a lawyer first," in the comments and tell us why. The investigation moved faster than anyone expected. FBI agents pulled Rabin's warrant applications going back 3 years, a process that should have taken weeks but was expedited given the nature of the complaint. What they found was not an isolated incident. It was a system. 12 warrants. Same CI source code. Same vague descriptions of controlled buys. Same Friday afternoon filing pattern. Same judge rotation strategy. All of them targeting buildings in predominantly Black and Latino neighborhoods where residents were statistically less likely to challenge entry. Internal Affairs flagged the 2 prior investigations that had gone nowhere. One had involved a defense attorney questioning a warrant's validity during a suppression hearing. The other had been a civilian complaint that was dismissed as unsubstantiated. Both times, Rabin had survived with minor reprimands and mandatory retraining that clearly had not changed his behavior. On Tuesday afternoon, a junior FBI agent named Kyle Preston was reviewing the digital surveillance files attached to the original warrant application when he noticed something that made him sit up in his chair. The logs included timestamps for pre-raid observation of the target location. Standard procedure. But these observations had started 3 weeks before the warrant was even drafted. Preston cross-referenced the dates with the confidential informant's alleged controlled buys. The buys supposedly occurred in early October. The surveillance photos were dated mid-September. He opened the image files. Most showed the building exterior, street traffic, vehicles coming and going. But 3 of the photos showed something else. A woman jogging. Same woman in each shot. Different days, different times, but clearly the same person. Preston pulled up Tina Hallman's driver's license photo from the federal database. The match was immediate. He flagged the finding and sent it up the chain. By Wednesday morning, the investigation had shifted from a defective warrant complaint to something far more serious. Rabin's team had not been investigating drug activity at that building. They had been surveilling Tina Hallman. For 3 weeks. Before any warrant. Before any probable cause. Before any legal justification whatsoever. The question was why. 2 weeks into the investigation, the FBI recovered the body camera footage. Standard policy required narcotics officers to activate cameras during warrant executions, but Rabin's unit had developed a habit of technical failures: cameras that malfunctioned, footage that corrupted, batteries that died at convenient moments. This time, Officer Lauren Pierce's camera had stayed on. The footage showed the stairwell, the door, and Tina's voice coming clear and composed through the audio feed. It also showed something else. At timestamp 7 hours 16 minutes and 22 seconds, just before Rabin approached the door, he turned to Vance and Pierce and muttered that it was payback time. The FBI transcribed the audio. They played it for Internal Affairs. They played it for Tina's supervisor. Then they started pulling Rabin's phone records. The pattern emerged quickly. Over the past 6 months, Rabin had exchanged more than 200 text messages with a contact listed simply as Torres. Officer Randall Torres. Former partner. Close friend. The same Torres who was currently serving 12 years in federal prison after Tina Hallman prosecuted him for evidence planting and civil rights violations. The texts were not subtle. Torres, writing from prison, had complained bitterly about the prosecutor who had destroyed his life. Rabin had responded with assurances that he knew who she was, knew where she lived, and could make her understand what it felt like to have cops show up at her door. The retaliation motive was not an inference. It was documented. FBI agents interviewed Vance and Pierce separately. Both were offered the same deal: cooperate fully, testify truthfully, and the U.S. Attorney's Office would consider reduced charges. Pierce broke first. She admitted they had known exactly whose door they were knocking on. Rabin had told them this was about sending a message. The warrant was intentionally defective. They expected Tina to either back down or file a complaint that would get buried in Internal Affairs like all the others. What they had not expected was for her to stand in that doorway and systematically dismantle their authority using the exact laws she prosecuted every day. Vance corroborated the account. He added that Rabin had been surveilling Tina for weeks, documenting her routines, her schedule, her morning runs. The plan had been to execute the raid on a Saturday when she would be home, catching her off guard and demonstrating that even a federal prosecutor was not untouchable. The scope of the investigation expanded. Agents pulled 3 years of warrant applications from the entire narcotics unit. What they found was a pattern so consistent it could have been a template. 27 warrants. Same structure. Same fictional CI. Same Friday afternoon filing strategy. Same judge rotation to avoid any single magistrate seeing the pattern. Same targeting of predominantly Black and Latino neighborhoods where challenges were rare and convictions were easy. The downstairs tenant, a 32-year-old graphic designer named Elijah Rivera, was interviewed at his studio. He was baffled. He had lived in the building for 4 years. No drugs. No criminal activity. The only unusual visitor in recent months had been his younger brother, who stopped by twice to borrow art supplies. That was it. That was the entire basis for the fabricated surveillance report. Rivera had not been home the morning of the raid. If he had been, he likely would have opened the door. Internal Affairs and the FBI expanded the probe. 3 more officers in Rabin's unit were found to have participated in at least 5 of the fraudulent warrant executions. The unit supervisor, Lieutenant Gerald Brennan, had signed off on every one. Either he was complicit or he was incompetent. Neither option would save his career. Tina was formally recused from any direct involvement in her own incident, but she remained lead prosecutor on the broader pattern of misconduct case. The irony was not lost on her. Rabin had tried to intimidate her into silence. Instead, he had handed her the case that would dismantle his entire unit. The evidence mounted steadily. Warrant templates with identical language. Body camera footage from other raids showing the same pressure tactics, the same refusal to present warrants, the same threats of obstruction charges. Text messages between unit members joking about easy busts and compliant judges. Financial records showing Rabin's off-duty work for a private security firm that specialized in evictions that conveniently increased in buildings where his narcotics unit had executed warrants months earlier. On a Friday afternoon in late November, Rabin met with his union-appointed lawyer in a conference room at the Fraternal Order of Police building. The lawyer, a man named Patrick Doyle who had defended 36 officers over a 20-year career, laid out the situation with brutal clarity. The FBI had the body camera footage. They had the phone records. They had Pierce and Vance's sworn statements. They had the surveillance photos of Tina. They had the warrant templates. They had Torres's prison communications. And they had 27 victims whose convictions were now under review. Rabin's expression, which had held firm through 2 weeks of silence and defiance, finally cracked. The fear was visible now. Not the momentary fear of a confrontation going wrong, but the deeper fear of a man realizing that the system he thought would protect him had turned against him completely. Doyle asked if Rabin wanted to consider a plea agreement. Rabin asked what the charges would be. Doyle read from the draft indictment the FBI had shared as a courtesy. Deprivation of rights under color of law. Conspiracy. Making false statements to a federal judicial officer. Retaliation against a federal official. If convicted on all counts, Rabin was looking at a sentencing range of 8 to 15 years. Rabin sat back in his chair and said nothing for a long time. Outside, the city moved through its Friday evening routines. People left work, headed to bars, made plans for the weekend. Inside that conference room, Clinton Rabin understood that his life as he knew it was over. 9 months later, United States vs. Clinton Rabin, Kyle Vance, and Lauren Pierce opened in courtroom 4A of the James A. Uburn U.S. Courthouse. The prosecution team took its place at the left table. Tina Hallman sat second chair, organized files stacked before her, her expression calm and focused. First chair belonged to Jonathan Reeves, a senior prosecutor from the Public Corruption Unit who specialized in systemic cases. But everyone in the room knew whose case this really was. The defense occupied the right side. Rabin had retained private counsel after the FOP withdrew its support, a criminal defense attorney named Marcus Levine who had a reputation for aggressive cross-examination and creative legal theories. Vance and Pierce, who had accepted plea agreements in exchange for testimony, sat in the gallery with their own lawyers, waiting to be called. The jury, 7 women, 5 men, ranging from a retired school teacher to a software engineer, filed in and took their seats. Judge Andrea Thornton, appointed to the bench 3 years earlier after a distinguished career prosecuting organized crime, reviewed her notes and called the court to order. Reeves delivered the opening statement. He laid out the case methodically. 12 fraudulent warrants. 3 years of deliberate misconduct. A pattern of targeting low-income neighborhoods. A conspiracy to deprive citizens of their constitutional rights. And at the center of it all, a personal vendetta that had exposed the entire scheme. He explained how Rabin had surveilled a federal prosecutor. How he had drafted a defective warrant specifically to intimidate her. How that single act of retaliation had triggered an investigation that revealed decades of corruption. The defense countered with a narrative of good faith mistakes. Officers working dangerous jobs. Split-second decisions. Warrants reviewed and approved by judges. If errors occurred, they were procedural, not criminal. Intent mattered. And intent, Levine argued, had never been to violate anyone's rights. The trial lasted 3 weeks. Tina presented the evidence in layers. First, the warrant templates, 12 documents with identical structure, identical language, identical fabricated CI codes. She displayed them side by side on screens mounted throughout the courtroom. The repetition was damning. This was not negligence. This was method. Next, the Friday afternoon filing pattern. She showed timestamps for all 27 warrants. 23 had been submitted between 4:30 and 5 p.m. on Fridays. She called a clerk from the magistrate's office who testified that judges reviewing warrants during that window often had a dozen or more applications to process before closing. The pressure to move quickly was understood. Rabin had exploited it systematically. Then came the racial targeting data. A statistician testified that 79% of the fraudulent warrants targeted majority Black or Latino neighborhoods, despite those areas representing only 42% of the city's population. The disparity was statistically significant beyond any reasonable doubt. The body camera footage played on the courtroom monitors. The jury watched Rabin mutter about payback to his officers. They watched Tina demand to see the warrant. They watched Rabin sweat and deflect and retreat. The footage was 13 minutes long. No one in the courtroom moved. Judge Harlan Brooks took the stand on day 9. He was 63, silver-haired, and visibly angry. He testified that he had signed Rabin's warrant on a Friday afternoon after reviewing what appeared to be a complete affidavit. He had trusted the affiant's representations. That trust, he stated clearly, had been deliberately betrayed. Brooks confirmed he had signed 11 other warrants from the same unit over 3 years, all of them now under review. His testimony was damaging not because it implicated Rabin directly, but because it established how the system had been manipulated. The phone records came next. Text messages between Rabin and Torres. Complaints about Tina. Threats of retribution. Plans to teach her a lesson. The messages were read aloud in court, Rabin's own words echoing through the room. Pierce and Vance testified under their plea agreements. Both described the culture in the narcotics unit, how fraudulent warrants were routine, how supervisors looked the other way, how the attitude was that ends justified means. Pierce testified that she had participated in 17 of the 27 fraudulent warrant executions. Vance testified that he had known the CI listed in Tina's warrant was fictional because Rabin had told him so directly. The defense attempted to argue good faith. Levine cross-examined aggressively, suggesting that the warrant templates were efficiency tools, that the Friday filings were coincidental, that the racial disparities reflected crime patterns rather than targeting. He called a police procedures expert who testified that the Fourth Amendment allowed for reasonable mistakes. Tina dismantled it in redirect. She walked the expert through the surveillance photos of Tina jogging, photos taken weeks before any warrant application, with no legal justification. She asked the expert whether surveilling a federal prosecutor for purposes of retaliation qualified as a reasonable mistake. The expert declined to answer directly. She then introduced evidence that destroyed any remaining claim of good faith. 19 people whose convictions were based on Rabin's warrants had been released pending review. 5 had already been exonerated completely. The cases had collapsed not because of technicalities, but because the underlying evidence had been fabricated from the start. The defense rested without calling Rabin to testify. Closing arguments came on a Thursday afternoon. Reeves summarized the evidence, drawing the connections between individual acts and the larger conspiracy. He reminded the jury that power without accountability was tyranny. He asked them to send a message that no badge, no uniform, no position of authority placed anyone above the law. Levine made a final plea for context. These were officers under pressure, in dangerous situations, doing their best. Mistakes were not crimes. The jury retired to deliberate at 3:47 p.m. They returned 6 hours later. Guilty on all counts. Deprivation of rights under color of law. Conspiracy. Making false statements to a judicial officer. Retaliation against a federal official. Rabin sat motionless as the verdict was read. Vance and Pierce, their plea agreements already in place, left the courthouse through a side entrance. Levine filed notice of appeal immediately. Sentencing came 8 weeks later. Judge Thornton reviewed the guidelines, considered the scope of harm, and noted the aggravating factor of targeting a federal prosecutor. She sentenced Clinton Rabin to 8 years in federal prison. His pension was forfeited. His law enforcement certification was revoked permanently. Kyle Vance received 30 months. Lauren Pierce received 24 months. Both resigned from the Philadelphia Police Department as part of their plea agreements. 3 additional officers from the narcotics unit were charged in follow-on cases based on evidence uncovered during the initial investigation. All 3 were convicted. 8 others were fired for conduct-related violations. Lieutenant Gerald Brennan, the unit supervisor, was allowed to retire with reduced benefits in exchange for his cooperation. He testified that he had failed to scrutinize warrant applications adequately and had created an environment where shortcuts were tolerated. The narcotics unit was disbanded entirely. Its cases were reassigned. Its remaining officers were scattered to other divisions under heightened supervision. The Philadelphia Police Department, facing federal oversight, implemented sweeping reforms. Every warrant application now required review by a legal advisor before submission. Officers were mandated to complete 40 hours of Fourth Amendment training. Quarterly audits by an independent monitor were established. Body cameras became required equipment for all warrant executions, with automatic disciplinary action for any technical failures. 19 prior convictions based on Rabin's fraudulent warrants were vacated. 5 people were released from prison immediately. 7 others had their sentences reduced pending resentencing hearings. The city of Philadelphia paid over $18 million in civil settlements to victims of the fraudulent raids. Tina Hallman returned to her loft in Fishtown. The downstairs unit now housed a schoolteacher who played piano on weekends. The neighborhood had not changed, same coffee shops, same old brick, same morning joggers passing by warehouses slowly being converted into homes. Her caseload had increased. The Public Corruption Unit, emboldened by the Rabin conviction, had expanded its investigative scope. Tina prosecuted 4 more officers that year. Her conviction rate remained above 85%. In the spring, she was invited to deliver a guest lecture at the University of Pennsylvania Law School. The topic was civil rights enforcement and the importance of constitutional literacy. She stood before a classroom of second-year students and told them the story of a Saturday morning when 3 officers knocked on her door with a fraudulent warrant. She told them what she had done. She told them what happened next. And she told them why it mattered, not because she was special, but because she had known her rights and refused to be intimidated. 1 woman. 1 defective warrant. 1 refusal to step aside. The system that had protected corrupt officers for years collapsed because someone inside that system finally held them accountable. Not through protests or petitions, but through the methodical application of law. Justice was not a spectacle. It was a process. And when that process was followed without compromise, it worked. Clinton Rabin was serving his sentence at FCI Schuylkill, a low-security federal correctional institution 2 hours west of Philadelphia. His earliest possible release date was 7 years away. His pension was gone. His career was over. His name had become shorthand in police reform discussions for everything that could go wrong when authority was abused and accountability was ignored. The Philadelphia Police Department remained under federal oversight. The reforms were holding. The warrant approval process had been transformed. And in neighborhoods across the city, people were beginning to learn what Tina Hallman had always known. Your rights exist. But only if you know them. Only if you demand them. Only if you refuse to step aside.